my bag.
Press speak and it'll. Yeah.
Okay, welcome to Law and Licensing. If we can take some time and just everybody introduce themselves, we'll start with Ben here up front and then move to the back.
So I am Ben Rasmussen. I'm the Director of Law and Professional Practices here at the board.
I'm Michelle Buse. I'm an Assistant Attorney General assigned to the State Office of Education.
Travis Rollins, I'm the Educator Licensing Coordinator for the State Board of Education.
Shauna Moss, with Teaching and Learning.
Linda Hanson, Board Member. In the wrong place.
Whitney Phillips, Chief Parent Staff.
Colin Kingsbury, Utah Department of Health.
Noel Taxon, Children's Special Health Maintenance, and I'm also a little guest.
I'm Tanya Surratt. I'm the Autism Specialist here in the Special Ed Department.
Okay, wonderful. Is that everybody?
I'm Debbie.
Oh, I see you.
So Debbie Davis, Director of Internal Audit for the State Board.
Awesome. Okay, welcome. And we'll go ahead and get started. Our first item is 2.1, External Data Request from URAD. And we'll have Whitney go ahead and come up.
Pull what up? You just press speak.
Oh, the contract.
Sure.
Sorry.
Yeah, can you, Ben, do that for me?
Yeah,
Thanks. Hi. Hello. Good morning. So you can go ahead and get started with the contract.
Sure. The Student Data Protection Act in the last legislative session required that the Utah State Board of Education enter into a data sharing agreement with URAD, but it did say that the board could make rules on what that agreement would look like. Is it October or November, the board approved changes to R27747, which went through what an agreement would look like. If you recall, sorry, my heart's beating fast. I think I'm running. If you recall, it required that the agreement allow for parents to request expungement of the data. It also required that URAD provide an annual report saying how the data are being used, and that that report be presented to the board. We specified a little bit more that the report be sent to the Law and Licensing Committee in this agreement. And so if we go down to paragraph 5D, and I can answer any questions about this. Here's where, upon written parental consent, the Utah Department of Health, which is also URAD, shall expunge any requested student person identifiable information from all databases. And if we go to J, thanks, Ben. Here it requests that the Utah Department of Health shall annually report to USBE Law and Licensing Committee a report describing the results of all projects and research undertaken using student data. In the board rule, it says just personally identifiable information, and I changed that to include both personally identifiable and de-identified. The report shall include how the uses of data have improved the quality of instruction and education in Utah. So that may include LEAs or our own Department of Special Education to report how those uses, how the research has improved education.
Wonderful. Do board members have any questions for Whitney? And I believe URAD is here if we have any questions for them too. And so is URAD in?
Yeah, would you like to talk to them?
I just want to make sure that, are they okay with the contract terms? Okay. Okay. Did we have any public comment on this? I don't think anybody signed up, so we'll go ahead and seek a motion. Sorry. Board Member Cummins, Brittany Cummins.
So is the motion that you're looking for to approve the data sharing request or the document? Because the board docs only has a data sharing request as an actionable item. There isn't something to approve a document.
This is part of the request, right? The agreement?
Yes, and this would move forward to the full board meeting next month for approval.
So I guess the external data request from URAD.
But what about the agreement?
The agreement is the request, right?
Yes.
Okay.
Okay, just making sure.
What about this document?
Let me open this up. I'm sorry.
I agree with you, and especially if the document's been changed.
Um,
Has the rule been changed?
Yes, the rule's been changed.
The rule was passed. So I am reminded that there are two external requests here.
Right.
One of them is for URAD, and this one requires an agreement because it's personally identifiable information. The other one, if you remember, we have a ticketing system where people will come in and ask for this information, and just coincidentally, this request was for aggregate level data with students with autism, but this is very low risk data disclosure in my opinion, because all they're asking for is total student enrollment, total special ed enrollment, total number of students with autism spectrum disorder by county or district. And so there's really high end sizes there. So these are two different requests.
Okay. Yes, Board Member Brittany Cummins.
So my question is now compounded. So now we have a contract and then 2 external data requests, and yet the actionable item on our agenda is an external data request from URAD.
Right. 2.2 is the other one, I believe.
Yeah,
That's different, isn't it? Internal data, those are 2 different
Oh.
requests under 2.2.
I don't know how this got, I didn't label this way, so I'm not exactly
okay.
sure how the title got changed. This was supposed to be just external data requests with 2 different items under it, so I
okay.
apologize.
So action 2.2, is that also the second one? That's an internal one? Oh, so there should be 2.
This
There is one under internal.
Yeah, the Kelly Lewis, University of Massachusetts, not listed anywhere.
Right.
This-
Yeah, so we can't take action on the Kelly Lewis one because it's not listed.
Okay.
Can we not?
Let me look at it.
Sorry, the action here when I titled it was
Kelly
just
Lewis is
external
different.
data request. I think that it was modified to say URAD by someone else to make this a little bit more transparent that it was the URAD request.
Oh, okay.
And I wonder if it was because there's not a data sharing agreement. But
At the same time, the public's got notice.
the public does,
That document that they're going to review.
So
I agree. I mean, can I speak?
Yes.
I mean, I think that the question is there a risk that somebody is going to argue that they didn't have enough notice about the University of Utah request? It has been in there in the document. So
it's not the University of Utah request I'm concerned about, it's the Massachusetts one.
Oh, that's what I meant. I meant the University of Massachusetts. So that is the question, whether members of the public would have.
Oh, yeah. Is there a rush with the Massachusetts one? If
No,
we-
there's not.
Can we separate the 2?
Yeah, we'll separate them, but, okay. So, does anybody, Board Member Belknap?
Yeah, then I still have a question on this data sharing agreement, not the data request.
Sure.
Has that already been signed, and this is just to show us what's here? So we need to approve the agreement and the request to share the data.
I see them as one and the same.
They're
Okay.
the same.
All
That's
right.
what our.
And no,
order
nothing's
says.
been signed. This comes before this Law and Licensing Committee, then it goes to the full
okay.
board, and then the Department of Health,
You're just
URAD
giving all
signs
the
it,
pieces of the puzzle.
and then the superintendent, yes.
Okay. Are you okay with that? Okay, I'd like to make a motion that we approve the data request from the Utah Department of Health and the University of Utah.
Okay, so the motion before us is that we
have the real motion in front of me, so.
accept the request from the Utah, oh gosh, I lost it. And approve the data sharing agreement from the Utah Department of Health.
And send to the board on second and final.
And send to
reading.
the board on second and final reading. Well, I guess we don't have to do
You don't have
that.
to do readings on these.
Okay,
Just say, and
great.
approve, and recommend
Okay.
that the board approve it.
Any discussion to the motion? Seeing none, we'll all vote. All in favor, say aye. Aye.
Aye.
Any opposed? Terrell's on.
The heavens have
Yes.
opened.
Okay, all right, that
Okay.
one passed, and then we'll take care of the Kelly Lewis
Yeah,
one
I'll do it next, thank you.
next week. Thank you.
So are you here for this?
So then the internal data request, that's a different
That's
one.
you too, right?
That's you too, isn't it, Whitney? Yeah. Okay. Okay, so Whitney, go ahead.
Okay. Okay. Camilla's not here, but I can speak to this. This actually, we're not going to be disclosing any data. This is based on a state statute that passed the last legislative session on after-school program funding. And we will actually not be disclosing any data. We will be receiving data from DWS for a program evaluation of this state-funded education program.
So why are we?
Because we need to enter into an agreement with DWS to exchange data. We just initiated drafting it.
Oh, okay.
Okay. Yes, Board Member Belknap?
Thank you. Are there 3 agreements here?
Yes, that's the first one. And then the second.
They're all listed. So we should just do one at a time.
Yeah.
Okay.
Board Member Lisa Cummins?
At any time, will this data be then shared with the legislature?
There is a requirement to have a report on the evaluation, but no person identifiable information will be reported. It will be
Just how the program-
aggregate on the effectiveness of the program.
Sure. I'd like to make a motion.
Okay.
I'd like to make a motion that we adopt the internal data request for personal identifiable information, the summary of internal data sharing request, interagency data agreements with Canyon and San Pete South and.
We're just doing Department of Workforce.
Just the first one.
Just Department of Workforce? Oh.
Right now.
Then I'll scratch that and start over again. So I propose that we approve, thank you, the data sharing agreement with the Department of Workforce Services.
Okay. So the motion before us is that we approve the contract agreement with the Department of Workforce Services. Any discussion to that motion? Seeing none, we'll vote. All in favor?
Aye.
Aye.
Okay. Any opposed? Okay, motion passed unanimously. And then the next one, the Utah Department of Corrections, is that the same?
Do you want Brian to be here? Do you want me to text
These are, yeah, I thought he would be here. This is the same purpose with 2 different districts. And so we have South San Pete and Canyon School District. And this is, from what I understand, we work with the Department of Corrections and ask a third party to provide education to incarcerated or youth in care. Okay. Any questions? Board Member Lisa Cummins?
I propose that we adopt the agreement between the Utah Department of Corrections and South San Pete School District. Should I include the Canyons one as well, since they're the same contract?
Yeah. May as
Or do
well.
we want to separate those as well? Okay, so I'll also include the one with Canyon School District to adopt in the interoperable agreement of sharing data.
Okay, so the motion before us is to approve the data sharing agreement between the Utah Department of Corrections, South San Pete, and Canyon School District.
Mm-hmm.
Any discussion to that motion? Seeing none, we'll vote. All in favor?
Aye.
Terrell, are you on still?
Yeah, did you not hear me? I said yeah.
Oh, okay. Okay, motion passed unanimously. And I think that's it, right? Or do you have another?
I think, no, that's all. Thank you.
Okay, awesome. Thank you, Whitney. Okay, we'll go to item 2.3, action pedagogical performance assessment standards. And Diana.
Shonda.
Oh, Diana and Shonda.
I miss Diana.
There we go. So we're back again. Shonda does all the work. I get to just kind of tag along. So I want to make that clear. Last month, you decided to delay looking at or approving the standards because we were kind of in the middle of that public feedback part. And so Shonda's going to talk to you today about that.
Yeah. So we appreciate having the additional month to review and respond to the public input and professional review. Part of this public input and review process included, we had an online survey and comments that went out to the public, and got responses. We had a contracted education consultant review. We led focus groups, 2 online focus groups and an informal focus group with curriculum directors. And then the writing team, of course, came together with reviews, bringing to the table things back from their district and from their universities. We also invited the UEA to join us at the table for our writing team meeting to revise the draft. There weren't a whole lot of changes, but we did look at the main points of feedback. Those are recorded in the report that was involved or was submitted along with the draft. Most of the changes were minor for clarity purposes. Probably the most obvious one was that we had a lot of comment on having the Utah Effective Teaching Standard heading written with our standards, and a lot of people felt it just wasn't necessary and that the standards speak for themselves, and to just refer to the Utah Effective Teaching Standards rather than try to summarize them on our standard list. So that's probably the most obvious change we made in terms of clarifying things.
What did you just say? Would you explain that to me one more time?
Yeah,
I'm sorry. I mean, I have read this thing. I live by this in my world, and I don't know what you meant by what you just said.
About the most
Biggest
obvious change?
Yes.
Yeah, so in the original draft, we had that.
Oh, from the draft,
yes.
Not from what's already printed. Okay,
correct.
Now I got it. Okay. Thank you. I'm going.
And then which draft are we looking at? We have
Draft 2.
There's 2 of them.
Yeah, one of them has the tracked changes, and then one is just a clean copy of it.
Oh, okay.
The same document, just showing how we got there.
Okay. Thank you for putting that on there.
And then if you needed to look at draft 1, we included that as well in case you wanted to see a clean draft, tracked changes, and another clean draft.
And then I see some new people have come in. I don't know if any of them wanted to give public comment on this pedagogical performance assessment standards. Nope. Okay. Just making sure. Board Member Belknap?
Okay, just double checking and following up, Shonda. Is this a required process in each district, but they can do it their own way?
They will be able to choose their assessment they want to use that will be submitted to us for an approval process. And
But every LEA has to do that? Only?
Every educator preparation program for professional licenses.
Okay,
Yeah.
all right. And how will, I didn't notice any changes here that are going to change how things are being done now.
Well, the change in how things are being done now is we don't require the pedagogical assessment. We have the Praxis 2, which is a multiple choice. So this supports the board's direction to have a pedagogical assessment and to have multiple assessments available. And in that rule, when it was passed, a part of that was that we would create standards that then you would approve, that once these are approved, then that lets us now put out a request for information and say, oh, here are some that you can choose from, and if you have a different one that you'd like to use, submit
Then
that.
submit it,
And we
okay.
would have a review process. I mean, that would be what we would do now internally, is develop the process that would lead to the gold star on assessments, and that this is required after January 2020 for students entering programs after January 2020. So it's just another piece of those licensing changes.
on the way.
Okay, thank you.
Board Member Brittany Cummings?
I move that we approve the Utah Pedagogical Performance Assessment Standards.
Okay, so the motion.
Draft 2.
So the motion before us is that we approve the Utah Pedagogical Performance Assessment Standards Draft 2 on first reading. Oh, we don't have to do that. Perfect. And send to the board for final approval. Any discussion to that motion? Okay, seeing none, we'll vote. All in favor say aye. Aye.
Aye.
Any opposed? Okay, motion passed unanimously. Thank you. Okay, 2.4, action R277-707, enhancement for accelerated students program. And we've got Nathan and Ben. Oh, we have one more person.
Nathan and Company.
Nathan and Company.
Garrett Rose.
Okay, so this rule was in front of the committee last month, and there were a couple of key concerns that we've tried to address in draft 2, which is included on board docs now. The first big concern we had was with regards to the consistency with the definitions, and so we've tried to update the definitions to try and perhaps make that a little more clear. What we've done is we've basically said that an accelerated student is a student in an accelerated program. An accelerated program is the gifted and talented, the advanced placement, and the IB programs. So we've tried to, that's basically what we've done with the definitions there. You can look at the changes that we've made there. The other big change that we made was with regards to the concern over not allowing prerequisites for participation in the accelerated programs. So if you go down to, let's find the line number here. To line 137, you can see the language that we tried to use there to address that concern. So on line 137, we've stated that a middle school or a high school, through consultation with students, parents, educators, and administrators, may consider academic readiness, but may not require prerequisites for enrolling in an AP or IB course. We felt that gave them the flexibility to counsel students, but still not limit their participation in these programs. So if you have questions about the changes we've made, Nathan and Garrett here will be happy to help you with those.
Okay, Board Member Brittany Cummins.
Just want to say thank you for your patience and for listening so well last committee. So thank you very much for your assistance on this. This is fantastic. So thanks.
Yeah, thank you. I believe all of our concerns have been addressed. So is there any public comment on this? I don't believe so. So I'm seeking a motion. Board Member Brittany Cummins.
I move that we approve R277707 on draft 2 on first reading and send to the full board for approval on second and final reading.
Okay, so the motion before us is to adopt R277707 draft 2 on first reading and send to the board on second and final reading. Any discussion to that motion? Okay, seeing none, we'll vote. All in favor? Aye. Any opposed? Okay, motion passed unanimously.
Thank you.
Thanks. And then, yeah.
We appreciate your patience.
Okay, we're gonna hold on items 2.5 and 2.6 as requested by a board member. She would like to come in and address these. So we'll move to 2.7, action R277-100, definitions for Utah State Board of Education rules, and Angie.
Yep. So you'll remember that last month we looked at a draft, I think it was draft 4 or 5 of R277-100, which defined homeschool student, dual enrollment student, online public education, et cetera. And the feedback was to try and simplify the terms as much as possible. And so I've updated the terms. I also included definitions for private school student, public school student, and split enrollment student to the list, and took out some of the definitions of online public school participation and instruction. You remember those were some terms that I think were maybe making it more complex than it needed to be. So if you want, I can just hurry and go through each of the definitions. I think you'll notice a trend. They're pretty simple, and in a lot of ways they focus on the LEA's ability to count that student as for purposes of generating state and federal funding. So dual enrollment student means a student who's enrolled simultaneously in a private school or homeschool and public school and is counted by an LEA in membership for purposes of generating state or federal funding for only those courses or subjects which the LEA provides instruction. Then homeschool student means a student who attends a homeschool, and I've directed to the language in statute that describes homeschooling, and is not counted by an LEA in membership for purposes of generating state or federal funding. Then We've got private school student on lines 103 through 106, means a student who attends private school, and I just left it broad so we don't get into the business of trying to define what a private school student is. But also, private school students would not be counted in LEA membership for purposes of generating state or federal funding. Then the public school student means a student who attends an LEA-governed public school and is counted by the LEA in membership for purposes of generating funding. And then split enrollment student, and this is a concept that's more fully fleshed out in 419, but it means a student who is regularly enrolled in 2 schools within 2 LEAs at the same time is eligible for graduation and other services at both schools and subject to the split enrollment provisions of R277419 and counted by each LEA in membership for purposes of generating state or federal funding for only those courses or subjects for which the LEA provides instruction. So again, split enrollment would be they're enrolled in, say, a traditional district or charter school, meaning a brick and mortar school might be an example, and then maybe they're doing an online, they're enrolled in another LEA, either district or charter online program. They might be 2 or 3 periods in one LEA and 4 or 5 periods in the other. So the idea is that they are enrolled in 2 LEAs, but the LEAs are only counting that student for the courses for which they're providing the instruction.
Thank you for providing the definition for split enrollment. I think that will help with a lot of confusion. Board Member Belknap?
Angie, I'm not sure, it's line 30, but it's the dual enrollment student. I don't know why that doesn't fit a split enrollment. If a dual enrolled student means a student who is in a public school.
And homeschool, though. We're split enrolled, they're both in public. They're in 2 public schools. They're splitting their time.
That, so help me here. A dual enrolled student means a student who is enrolled simultaneously in either number 1,
right,
a private school or homeschool, or number 2 in a public school.
So they're both
thank you.
dual enrolled twice.
It just takes me a minute.
And so this helps too for purposes of when you do have homeschool students that are participating both in homeschool and in private or public school, that they are now actually dual enrolled students. And I think this will help as we now probably next steps will be to look at the rule on dual enrollment. And we kind of talked last time about maybe providing, for example, I've heard from LEAs that we have this affidavit on the exception or from compulsory education, that it would be helpful to have one of those for dual enrolled students so that the LEA could make it clear that they are responsible for the student only for those times, those courses that the LEA is providing instruction, and then that the student's exempt from compulsory ed for the portion of the homeschool.
Right.
And
well,
then
they do have to sign a affidavit for dual enroll.
Yeah, well, we just received some feedback from LEAs that they'd like a form that would be a model form that they could use, similar to the affidavit that's a full exemption from compulsory ed, but that would be one that they could have for their dual enrolled students.
That's a whole other topic.
Yeah, but we'll get into that. It just helps, I think, get the terminology correct,
Okay.
And just for clarification, I have a situation where a parent is an online. Now I'm looking for the new terminology.
Split enroll?
It's probably, split enrollment, but they want to take a charter class that is provided at another charter, and they're being told no because of the money situation. How does that work with statute?
Yeah.
Does that?
So that's a good question. So dual enrollment is explicitly kind of a right of parents, meaning an LEA cannot deny a student enrollment in their district or in
the public school part.
The public school in which they reside.
Right.
So for example, you've got either a charter school student who wants to take a co-curricular course at their boundary school, or you have a homeschool or private school student that wants to dual enroll into a course into their boundary school. That you cannot deny. But if you have a student who is either going to a district or charter school, and then they want to split enroll at their discretion in another school, that is not required to be, that's discretionary at this point. We actually talked about that a number of years ago when we talked about the split enrollment concept, and there's another rule that talks about students, charter school and online school student participation in co-curricular and extracurricular activities. And the question was, if a student wants to enroll in 2 public schools, but the second public school is not their boundary school, like the school that they would normally be assigned to go to, do we want to mandate that a school facilitate that? And the board said at that time no, because it created a lot of unintended consequences. For example, you've got a charter, and I'll just give you one that was discussed then, and I don't know that anybody on this committee was on the committee at that time. You may have been, Brittany. Leslie Castle was chair at the time, so it's been a while, and it might be a worthy discussion again. But most of the time, students who are attending a public school, at whatever school it is, and then they want to attend another public school that's not their boundary school, it's usually for a very popular course, say for the most popular choir teacher's course or a very popular history or math teacher.
Well, in this particular case, she wants to attend a Navy class that only this one particular school offers, and they're not finding it anywhere else.
Yeah.
And they're saying no.
So the LEA could allow that, but they're not required to, because what they could just say is, well, then come and enroll in our school completely. So it's only for that student's boundary district school that the boundary district school does need to facilitate allowing them to participate. But other than that, it's discretionary.
Okay. I'm wondering if maybe in the definition we should add at the discretion of, or will that be more outlined in the rule?
Oh, yeah. Yeah, that'll be outlined in the rule. So,
and I guess statute doesn't really govern that?
Well, there's nothing in statute that regulates or has addressed split enrollment. They've only addressed dual enrollment. So what you're talking about is split enrollment. The student's in one public school and wants to attend a second public school. Currently, state statute doesn't provide any rights, doesn't say anything for or against it. They only have addressed dual enrollment, which again is the home or private school student who's also in a public school.
So, if I may, Chair, so that might be a topic of discussion during this legislative session, especially if they're going to talk about personalized learning, even more so this next session. You know, if they're going to allow that. I mean, if there's only one class is in this district at that one school, and, you know, and she wants to go be a Navy SEAL, you know, how can she take another? Anyways, so that may be a topic of discussion further.
Board Member Brittany Cummins.
I just wanted to once again say thank you to the staff who listened to us last meeting, and so with so much talent and flair put it together so well. So thank you very much for this flair. That's Angie's.
Thanks.
So thank you. I love it. So.
Okay, so no other discussion. I'm seeking for a motion. Board Member Lisa Cummins.
So I move that we adopt R277-100 on the draft 7 and move it to the board for second and final reading for approval.
Okay, so the motion before us is to approve R277-100, draft 7 on first reading and move to the board for approval on second and final reading. Any discussion to the motion? Seeing none, we'll vote. All in favor? Aye.
Aye.
Any opposed? Motion passed unanimously. Okay, and then 2.8 is an action. This is the board resolution that was brought forward by Elisa Ellis.
And the Eliminating Barriers Task Force.
Oh, yeah, and the Eliminating Barriers Task Force. And then Ben.
We never got the updated draft board docs.
Oh.
Oh.
Oh, yeah, we have the I think this is the other.
Do you have the updated one? Maybe you can just show it. Did you send it to me? Because I could ask.
I think, was it sent to all the committee members, or?
I think so. I'll send it to Kathy and have her post it really quickly.
Okay, so this is, I think I've got up there what the updated.
Here it is. Yeah, it was sent to all the board members.
Of the committee, yes.
Of the committee, yeah.
Which day was that? Sorry, can you see?
The 3rd, December 3rd.
Okay. I'll send it to.
10:03.
Okay, thanks. I'll send it to Kathy then and have it posted.
Thank you.
Okay.
So this resolution originated from the Eliminating Barriers Task Force, wasn't it, Angie? That they wanted to do a resolution from the board in support of parental rights and the parents' role in education. The first draft we did of that resolution contained some language from a divorce custody case from the Utah Supreme Court, which some members didn't feel was adequately related to students' education as and the issue at hand. So I've done a second draft of this, which instead of using that language, uses some language from the code, which emphasizes some of a parent's statutory rights in education. We've sent this out for feedback and haven't gotten a lot of input, but we've got that draft in front of you if you'd like to, if you have any questions or want to discuss that at this point.
Board Member Brittany Cummings.
Is there a line just below that one on this one?
Let's see.
So I just have a question about the purpose of that last line. Is it necessary in a resolution to state that, or can that be removed?
Which last line?
That
be it further,
last, be it further
that
resolved.
could be omitted, and you could just give that instruction to the board secretary in a motion if you wanted to do that differently.
Okay. So I'd like to amend it that we remove that last portion. I move that we amend by removing that last paragraph.
Okay, Board Member Lisa Cummings.
I'll wait until this amendment is passed.
Oh, okay, so the amendment before us is that we strike out the last paragraph, be it further resolved. So, any discussion to that? Okay, seeing none, we'll vote. All in favor?
Aye.
Aye.
Yeah. Aye.
Any opposed? Okay, motion passed unanimously.
Chair, if I may?
Yes.
Is it valuable or is it necessary? I understand that in May we passed as a board, and I sent this to Ben in the email, I think everybody saw it, that after 4 years, any resolution that the current board passes, it will sunset unless it's renewed by the board itself. Is it necessary on this particular one to set a date?
So with the way that the board's policy is worded on that, the 4-year sunset is automatic unless the board chooses to put some other date in the resolution. So if you wanted it to be longer or shorter than 4 years, you could put in the resolution, this resolution shall be effective until X date. But if you just want it to go the 4 years, you would just leave it as is.
I almost, in my head, until the abolishment of the U.S. Constitution. But, no, but is it necessary or should we, is my question.
It's optional.
I know it's optional, but this is such a, I think this is what makes Utah stand out within the United States in education itself, that we are very pro parental rights and very putting that first, to recognize that I think if we put a sunset on that, I think it would damage it, but.
We already automatically have a sunset, so we can extend the sunset date from the 4 years, but
But that's what I'm
it's
saying, is do we
automatically-
need to have a date? Should we put a date on it? I'm thinking yes, but what is I would like to hear the discussion.
Board Member Brittany Cummins.
I think the purpose of that 4-year cycle was that we don't know what the board's going to look like in 4 years. And so it was always just that board would have the opportunity to consider any resolutions that are on the table or that are posted as far as them. And so they would have the opportunity to say, yeah, we resolved this exact same thing and we're a part of this as well. And so, I mean, even if we put a date into infinity, the board in the future still has the opportunity to reverse a resolution or remove it or whatever.
Yeah.
And so it really doesn't make any difference. It's not going to it's not going to solidify its permanency in any way over time. It just allows the board to have something, and it's a trigger that says the board now should look at this item and decide if it's something that they want to keep or not.
And if I may, Chair, would staff automatically bring it to the attention, of the board? Because there's been lots of things, that I wouldn't have known had the staff not brought it to the attention of the board, so.
In 4 years?
In 4 years.
Yeah, they'll bring it, right?
Ideally.
Yeah, that would assume that we all are.
Right.
That's
But
usually.
we should be, as we're deleting or eliminating those board resolutions from the website, then we should be bringing it to either executive leadership for it to be placed on an agenda for discussion. And that's probably the way it should go.
Okay.
With rules, we have an automatic legal requirement, and it's like trigger, the Office of Administrative Rules sends us a notice that, hey, this rule is going to sunset. And so that's the nice thing about getting
But
that.
this isn't a rule, this is a resolution.
It's not a rule, right.
It's a resolution.
So they wouldn't automatically
It wouldn't
get
catch
it.
their.
Not necessarily. So
Yeah.
Ben and I will do our best. Hopefully, we'll still be
Hopefully
here in
we'll
4
still be here in
years.
4
And we
years.
can do that for you. Yes, it is. Because we've already been here almost 4 years. So that'd be great. So that's the ideal.
Okay.
Board Member Belknap, did you have?
I just want to give clarity that what's on board docs is not the same that's what's up here.
Right.
Yeah, we just, it will now.
It will now?
If you look,
Because
it's
I'm
been
going-
changed.
I'm going, what about this?
If you refresh your board
It's-
docs,
yeah.
it should be there now.
Okay.
Can you just
So-
scroll up? Sorry.
And then you can make a motion.
Okay. Thank you. I just pressed the top. Thank you.
Board Member Brittany Cummins?
Sorry,
Did
I
you
just
have-
wanted to have it
Oh.
scroll up so I could see it. Sorry.
Okay. There's no public
Okay.
input, so. Board Member Belknap?
I'd like to make a motion.
Oh, yes.
But I'm trying to catch.
Oh, come to the,
I know.
the one on board docs is, well, it should be updated now.
So, and I may be behind.
State your name.
I'm Tracy Watson from the Utah Education Association.
Tracy,
and-
go to the third paragraph. That's where it's changed.
Well, everything's.
Everything's changed.
Well,
Just see. I don't know how to refresh on board docs. Okay, so we're not talking about assignments anymore. We've taken that out.
That was a motion there.
Yeah.
to take
Thank
that
you.
out.
Yeah.
not in board docs, I can't. Because board docs is.
Do you have it, Board Member Belknap?
There it is. Did Tracy get it? Did you get it?
Yeah.
Oh. Okay, I'd like to make a
Okay.
motion that we accept this resolution, that we approve this resolution?
Approve.
This resolution.
Before you make your motion.
Yeah.
So I'm going to renumber this as because the board will be voting on it in January, so this would be board resolution number 2019-1. So that should, your motion should deal with that number instead of 2018.
I'd like to make a
Okay.
motion that we approve this resolution, send it to the full board.
Okay, so the motion before us is that we approve the Utah State Board of Education Resolution Number 2019-1 and send to the board for final approval. Any further discussion to that motion? Seeing none, we'll vote. All in favor?
Aye.
Any opposed? Terrell, are you on?
Yeah, I said aye. I'm
Okay.
sorry.
All right. Motion passed unanimously. Okay. And I see that Board Member Lear is here. So we'll go back up to item 2.5. It's on for discussion.
Really? It should have been action, but it says action on the board doc.
Oh, okay. Okay, yeah, the board docs show action. That's interesting.
Anybody have a paper copy?
Yes, I do.
Sorry.
You can sit.
Do you want me up here, or do you want me to sit back there? Where do you want me to be?
Yeah.
You can come right there. That'll be fine. Okay, so we're on item 2.5, R277-551, Charter Schools General Provisions. And we will be looking at a rule draft brought forward by Board Member Carol Lear. And which one of you, Angie, did you want to start?
If you
Okay.
want, just to remind the committee the process or where we're at in the process with these rules. Both of these rules, 551 and 552, are rules that we worked on for a number of months. And last month, the board approved for filing 551 and 552, and they'll be open for public comment. I believe they're open for public comment right now. And then will take effect on or around November 7th through the 10th. Part of, after the board made that, did I say November? I meant January. Thank you. Yeah, that would be a long time to wait. It was approved in November. They'll take effect in early January. The second part of the motion was to have this committee also take a look at the rules again, because Board Member Lear had proposed a couple of amendments, and in lieu of including those amendments in the drafts that were approved in November, we're now going to take a look at those amendments. And one thing that I just wanted to mention that we did receive some feedback from the State Charter School Board that's not in here. They would just like to put, they'd like to delete a form on its website so that it, or provide on its website, take that out so that they could provide that form.
45.
It's on line 45, so it would just read, the State Charter School Board shall provide a form for individuals to report. They have other ways, they feel like, of providing that form that's not necessarily on the website, and that was something, is that correct, Jennifer? Okay. And maybe, because I can't remember the other change, maybe Jennifer, when we get to public comment, you could explain. Yeah, okay. So you can see the change in 551 is pretty small. It's on lines 48 through 51. So I don't know if Board Member Lear, if you'd like to speak to that.
I can just speak generally what and they seem like very minor amendments, but I feel like it's really important in these charter school rules to emphasize, and at every appropriate time, that the board has final authority over funding charter schools. These are public school students. The board, by the state constitution, is responsible for the public school system. And so when money goes out, and it's in the other rule rather than this one, but my general purpose in these amendments, however minor they seem, is to stress that the final approval and the final funding goes through the State Board of Education. I think that is important too for for the status of the Board of Education as a constitutional body. So that's the general purpose. This one is a pretty small change, as you can see on line 48.
Okay. We have public comment. Royce and Jennifer, did you? So if you want to come up. Is Royce here? I don't see. Royce stepped out. Okay, so we'll have Jennifer.
Sorry, thank you for the opportunity to put input. Yes, if you delete out on its website, then it just allows flexibility. We may put it on our website, but it just allows flexibility. And then the other changes on line 46 from individuals to charter schools, that probably was just a mistake from the original one because the statute, it says charter schools, not individuals. And so it's just to match statute. And so those were our two recommended changes.
True. So on line 46.
Yeah, so line 36 where it says for individuals to report,
it needs to say for charter schools.
Yeah, for charter schools to report, and then that matches what's in statute. And then those are my only comments.
So for a charter school is what we probably want to say.
For a charter school.
So the State Board of Education shall provide a form for a charter school to report threats. Yeah.
Okay.
Can I ask a question about that?
Yes.
So when you say for a charter school to report threats, and I don't have the statute in front of me, but you don't literally mean the charter school, you mean an individual, an administrator, and I wonder if that could be better stated.
So I'm not changing anything from statute, it's just from what it says in statute. It says, in accordance with rulemaking authority, shall make rules that require a charter school to report any threats to the health, safety, or welfare of its students to the state charter school board.
If it's poorly written in statute, we'll leave it that way.
Okay, thank you, Jennifer. Royce, did you have any?
Jennifer.
Oh, you have a question for Jennifer. Royce, did you have any other comment on, we're on
551 or 552?
551.
551. Trying to remember.
Do you want to see this?
Thank you, Karen. I think Jen and I talked yesterday, and I think we share similar concerns. She's expressed them.
You want to turn on your mic?
Oh, yeah, mic.
Sorry. Jen and I spoke yesterday, and I heard what she said. It sounds like she expressed the same things that I would have on 551.
Okay, thank you, Royce. Board Member Belknap?
Yes, this is actually for Jennifer. You said to take out on the website, okay, but your comment was a little disconcerting to me. We might put it on the website. In our day and age, I would like a little more firm. It will be on the website and other things, at least verbally to me. That was a little disconcerting.
So we have a application that all charter schools have access to. It's called UCAP, Utah Charter Access Point. It's what charters use to, for example, report their projections. And so we may want to put it into there because if we're thinking about how do we give access to the superintendent or her designee, what we could do is like what we do with projections. We could just give them access into that piece and then they can get the report at the same time. So it's for functionality.
So it is website.
UCAP.
Web-based.
Well, they access it through the website. I don't know if, and we could put the link on our website, but
Still web-based.
it just seems like,
Okay.
yeah, we're gonna put out a form, but to limit us to the website, it just seems limiting.
Okay.
Board Member Brittany Cummins?
Sorry. This particular rule was confusing to me just because of how the statute is written as far as, that a charter school, that an authorizer shall provide, or the state board shall provide this, require that this charter school board put this on there. But anyways, I think this is okay for now. But most of my questions were on the next rule, but. Yeah, I'm okay with this one.
Okay, Board Member Lisa Cummins?
So I have a little bit of concern, and I wonder if I'm the only one. If if the state board takes on this this extra, not extra, ability to approve or disapprove a charter after it's gone through the charter school process, are we in our limited viewpoint of how a school should be run, are we limiting our definition of what a school should look like? Whereas in a charter school board, there's more discussion on flexibility, on personalized learning, on ideas on how to change a school. I mean, charters vary across the board, on how they run their school. Pardon?
That's 552.
This rule isn't dealing with approving a charter.
That's what I'm saying. That's what I'm saying. Is this rule going to limit what types of charters open? No. Is this affecting anyway? This is one report, but we are still approving charters. Are we?
This rule, my understanding, it hasn't got anything to do with approving charters. It's just showing who and where they will report student health and safety and concerns and things like that.
That's what Board Member Lear hinted towards, that, that a final approval, so maybe clarification on my part is needed.
Okay, Board Member Lear.
I was probably being more general than specific to each of these rules. My general statement was, this is what I was what my concerns were in both of these rules, that there should be final board oversight. There's only a little piece of that in 551. It is more significant, and you're getting to it in 552. So I was probably more general than I could have been.
Okay, thank you.
Yes, Jennifer.
So the State Charter School Board does have concerns with 552, the proposed changes. But with 551, I believe that schools probably should be reporting these kinds of things regardless, not just charter schools. And so what this does by having, if we have to put a form that they're reporting to us, then it saves them another step of having to then also report to the superintendent, to this board. And so we can just help schools from that duplicative reporting. And so that's why we support this. It doesn't seem to impact the diversity of schools.
Okay, thank you. Okay, any other discussion or questions for? Nope. Okay, thank you very much. Okay, Board Member Belknap.
Yeah, I'd like to make a motion that we approve.
Wait.
With the what?
Don't we need to make motions to amend it first?
Okay. I'd like to make, well, can't I just make the motion with the amendments?
Here, yeah, let's.
Can I just say with the amendments?
Nobody made the motion.
We haven't.
Okay.
Yeah, we haven't moved to amend anything.
Shall provide a form for a charter school to report. So that's
Yes, but you could have told me that across the way.
I know.
Okay. So I need to amend first? Okay, I'd like to make these amendments that on line 45 and 46, that it says the State Charter School Board shall provide a form for a charter school to report threats to health, safety, and welfare of students consistent with subsection blah, blah, blah.
Okay, so the First Amendment before us is that.
That's that rule.
It's set up.
Want me to say it?
Oh gosh, where is it at? On line 45 through 47. Did we say strike out?
Yep.
Okay. Strike out on its website and insert
A charter school in lieu of individuals.
for a charter school in lieu of individuals. Okay, any discussion to that motion? Seeing none, we'll vote. All in favor? Aye. Okay, any opposed? Okay, motion passed unanimously. Now, we can.
Now, go. I'd like to make a motion that we approve R 277551 on first reading and send to the board on second and final reading.
Okay, so the motion before us is to approve R277-551, Draft 1 as amended on first reading and move to the board for approval for second and final reading. Any discussion to that motion? Seeing none, we'll vote. All in favor? Aye. Any opposed? Okay, motion passed unanimously. Now we'll go to item 2.6, R277-552, Charter School Timelines and Approval Process. And Angie, did you want to?
I think sure. Just the background that I provided before 551 is the same. 552 has already been passed last month, and part of the motion was for this committee to consider the amendments from Board Member Lear.
Okay, Board Member Lear, did you want to speak to your amendment?
I think Lisa's pointed out that it would be helpful if I'm more specific.
Okay.
Line 76, again, it says, prior to receiving state startup funds, an authorizer shall certify it in writing to the state charter board and the superintendent, because the funds come from the State Board of Education. They come directly from the state board, not directly, they come, that's the source, then they go through the authorizer. So the funds are state funds for which the board is accountable. I think it's appropriate for the superintendent to have final knowledge of that and approval of that on the board's behalf. Moving to lines 116 through 119. This is about the documentation that would be underlying information for startup funding. And so again, I think as being careful stewards of this state money, I think it's appropriate for the superintendent to receive documentation about startup funds that would go to a charter school. May mean that it's a quick review by her. It may mean that it's but she has it in her possession. She has the next be electronic possession. But again, that's, I think, the responsible thing to do for the board, to make sure that the superintendent has access to that information. Moving to line 165. Again, similar philosophy, but a little bit different issue. Within 45 days, the authorizer's approval of a charter school's request for expansion. The authorizer provides documentation of the satisfaction. We've had significant situations in the last 6 months, 8 months, 9 months with charter schools that we were surprised, we as the board were surprised, sometimes the state charter board, as in what I've heard, was surprised that, oh, these schools are not doing very well, or there was information we should have known. So providing this information, making it available to the superintendent, seems the responsible thing to do, because the board is ultimately responsible for those funds. Switching to line 198, within 45 days, a similar concept. The authorizer's approval of a charter school's request for one's an expansion, one's a satellite replication. Again, documentation is available to the superintendent that the requirements were met. And then at the very end, line 241, prior to accepting a charter school from another authorizer, a new charter authorizer shall request and consider information from the board and current authorizer of the charter school's financial and act. So we're just, again, as the responsible party, finally responsible for the funding of these schools, we are, even though it goes through an authorizer that could be the University of Utah or another higher institution, we're saying make sure you look carefully at the information as you take on this school. And it doesn't require anything more than shall request and consider information from the board as well as from the sending school.
Okay, thank you, Board Member Lear. Board Member Lisa Cummins, did you have a question?
I agree with the documentation. I think we should know if there's any problems, right? As far as the buck stops here at the state board level. But as prior to accepting a charter school, I think that's jurisdiction of the Utah State Charter School Board. In the statute.
Why are you saying that, Lisa?
That's 241, that's
On
coming
241.
from a different authorizer.
A different authorizer.
It's when the charter school.
You mean on line 241, is that?
Yes.
So it's talking about when a charter school wants to submit an application to a second authorizer. So let's say that currently
From
they're
another-
authorized by the state charter.
A new charter authorizer shall request, yes.
Yes, so.
I just
Yeah.
was trying to, I get
Yeah.
the principle, I
So-
just want to find out where
Yep,
she was.
I'm sorry. But on the statute, HB 313, could, Angie, maybe you could say, could line 73, 2A, the state board has general control and supervision of state's public education system, and then goes down to line 77, the board may not govern, manage, or operate school districts, institutions, programs unless granted by the authority by statute. Do we have that authority to govern and manage that?
So I think that language that you just wrote or read is about direct operation. So it would be us running a school the way a district has a relationship with a school. Are you still talking about lines 241 through 243?
Yeah.
So,
Right.
so what this essentially is saying is, I'm going to use State Charter School Board and Salt Lake City School District as an example. So let's say one of the schools that the State Charter School Board currently is the authorizer of. So I don't know, let's give an example that's near Salt Lake. Which one? Yeah, come on up, but can you just give me, which one?
City Academy.
City Academy. So let's say City Academy, who's currently authorized by the State Charter School Board, wants to change their authorizer to the Salt Lake City School District. What this language is saying is that Salt Lake City School District, before accepting City Academy and taking it from the State Charter School Board, that Salt Lake City School District has to ask the board and the State Charter School Board about the school's financial and academic performance, just to say, are there any problems? Have you all had, do you know of any financial or academic issues before they accept? And that would be Salt Lake City School District accepting the charter.
But isn't that the State Charter School Board's job?
Well, it could go the other way. Like, it could be that the Salt Lake City School District now has a school that now State Charter School Board. It's about giving the second authorizer knowledge about the school's performance before they accept it.
I understand that, but I'm saying, whose job is it? And according to Board Member Lears, it's the state school board's job to do that. What I'm saying is, are we usurping the Utah State Charter School Board and taking that job away from them under HB 313?
I don't think there's a legal problem, but I think that's a policy call. I don't think
Yeah.
it's.
Jennifer, did you?
So I think some of those concerns are maybe with some of the other changes. I think that these changes is in lines 241 to 243 are talking just specifically about getting information to the new authorizer. So I actually think that this was probably a miss from the prior version of this rule, that if you have, say if State Charter School Board is going to take on a new school, we want to be able to get good information from the authorizer and anyone who has that information. And so this, I think, just facilitates that they have to provide information. So you can't just, I guess if you're trying to sell like a used car, you have to say if there's going to be problems with that car or if it runs well.
Right, but that information is not going to go up to corporate, right? That's there at the local on-site facility, right? So are my concerns appropriate in another location then?
Yes, I would
Okay.
say so. I would say that some of the other changes are concerning to us. This, we felt, was a good catch, a good change.
If I may, I think part of
State your name off for the record.
Sorry, Royce Van Tassel, Utah Association of Public Charter Schools. And I think, as Jen said, this is a valuable thing. I would expect, frankly, that any new authorizer would do this regardless. But one can imagine weird scenarios where somebody may say, well, we don't want to give you that information. And it seems entirely appropriate to tell that receiving, or tell that giving authorizer, actually, you need to share that information. I mean, that's just part of being transparent to the public.
Sure.
Yeah, I do have to go.
I believe Board Member Lear is about to leave, so she wanted to add.
You're going to have to discuss this. It will come to the board again, so I feel like I'll have a chance to say these same things one more time. And I'm pretty sure I know what the Charter Board's concerns are, but I think it's really important to remind this committee, and then we'll say it again in the board meeting, that ultimately the Charter Board has no assets. The Charter Board has no constitutional authority for dispensing money to public schools. That has to come from the board. And so I feel like it's a really important responsibility for myself as a board member to make sure that our CEO, our superintendent, has a final opportunity to see how charter schools are changing hands, moving around, changing management, and then through her, we have the responsibility to manage those funds as responsible stewards. And until the Constitution is changed, we do have that responsibility. As long as it's not, I think Lisa's very right in pointing out that language that says the board cannot manage a school or govern a school. It's not management or governance. It is taking responsibility that the funds come through the State Board of Education.
Thank you, Board Member Lear.
Science standards.
Have fun. Okay. Board Member Brittany Cummins.
So on line 241 to 243, it's the shall is on the requester, but there's no obligation on the giver of the information. Do we need to add some information that would reciprocate the requirement that
That's a good point.
that giving authorizer shall provide?
Could do that. Let me see what we could.
That's a really good point.
It's a good point.
Because I could refuse.
That'll keep it, yeah, not gonna do it. Request all you want.
We're not giving you anything.
The state board
we're not
might
gonna
call
give you
that authorizer in and say, is that really the decision you want to make? 'Cause
Well, the board could refuse. We're not going to give you any information.
Yeah, that's a good point. Angie, did you?
Yeah, I'm just thinking of, I can't remember what the term is. Is it current authorizer? Is that what it's used? The current
The new
authorizer.
cha-
Okay.
Okay. Board Member Brittany Cummins, did you have anything else?
Yeah, I do, but
Okay.
it's a different section, so.
Oh, okay.
Can
I can work on that language real quick if you want to start talking
Okay.
about your other part.
So up on line 76. So I wonder, we've got authorizer in here and the State Charter School Board, which seems backwards and redundant. So are we trying to say, is it the fact that we want the authorizer to create a trigger for funding, right? And so we want them to certify. So here's the authorizer. The funding needs to be triggered at some point with the state because the funding comes through the state, through the
Right.
superintendent, right? And so they need to trigger. The startup funding does not come through the state.
Oh, yes,
Board
Board
of
Member,
Education.
I mean,
Actually,
I just stated. Jennifer? Or degraded, yeah.
So I think where some of the confusion comes with this change here and why we do not think that this change is appropriate is because if you look at, and where the startup costs are in statute, it's in 53F-2-705. Those funds come directly to the State Charter School Board. However, there are other authorizers authorizing schools. And so for the lines, it's like 75 through 80. We as the the entity that is given the funds by the legislature need this information from other authorizers. So we just need to know this. But then when you look at lines 80 on, that's for the Board of Education for any of the MSP funds, just like what Member Lear was talking about, that you are, since you're over the funds, before you will release it, you need the certification for these things. So first off, if you add superintendent in 76, it's rather redundant with the things that are being listed in 80 on. The reason why we called that out and we have those 5 lines is because the funds are given directly to the State Charter School Board, and the State Charter School Board we need to get information from other authorizers if we're going to be able to monitor that grant.
Okay.
Board Member Brittany Cummings.
And so then that on line 81, where it talks about certification to the superintendent, is basically what somebody was thinking they were accomplishing in 76, but it's just the wrong funding source.
It is already there.
It's already there.
Yeah.
So I'd like to move that we not add in and the superintendent on line 76.
Okay, so the motion before the board is that we strike out on line 76 and the superintendent. Is that correct? Okay. Any discussion to that motion?
Can you hold just 1 minute?
Yep. Okay, seeing none, we'll vote. All in favor? Aye. Board Member Warner, are you still on the phone? Okay, any opposed? Motion passed unanimously. Okay, Board Member Brittany Cummings.
So then 116 to 119, then is that additionally redundant?
That's what I'm wondering.
If I may.
Jennifer, yes.
So where we have concerns about this is that you, as the Board of Education, always have the right, if you have questions about someone's, say, certification or their assurances, to ask for documentation. That's where an audit is for, or you do that quite often. Well, I don't want to say it quite often, but you do that with schools and with LEAs, where you maybe have some questions, so you ask for documentation. And so I would argue that this is not needed, and it's actually very onerous, where you're asking all authorizers, regardless, you could have authorizers doing great things, you have no concerns, but they're still having to provide you this documentation. Why not just ask the documentation when you have questions, when you have concerns, you can request it, you already have that right. You don't need to have it where you're asking of everyone.
Okay, Royce?
If I may, there are a number of instances. Angie and I talked about this yesterday. There are throughout the code a variety of instances where, whether it's an LEA or an authorizer, makes a variety of assurances that say we have done X, Y, or Z. It is a very small subset of those where you say that the assurance in and of itself is not upfront sufficient, but we need additional documentation that the assurance is going to be followed through on. And as Jen noted, you would have that authority if there was a concern that comes up, but it's not clear why you want to, in advance, say, we don't trust those assurances. You need to back that up with all of this documentation.
Okay,
and I think
you,
that that basic issue gets repeated later on. I mean, it's the exact same language, the separate section, expansion versus satellite, but it's the exact same issue.
Okay, Board Member Brittany Cummings.
So can I just, sorry, I'm just having a hard time understanding these two different funding sources. So this 116 to 119 is in reference to the startup funds again, is that correct? So it's in what we talked about in subsection 2.
I believe it's to all MSP funding. So any funding MSP or anything that flows through
this
your
one
office.
is specific.
I think
to
this
subsection
one's
2,
just startup
which
still.
is just the startup funds.
Yeah, starting dates and facilities.
Right.
So it's still.
And then, but then it talks, so who distributes the startup funds? Who sends the check?
Our office.
It's our office, so it is the superintendent.
Well, let me just, I have.
So
So if I can answer that. So we utilize, we don't have an MOU. We need to have an MOU about this, but we do utilize your services for this. The funds are directly allocated to the State Charter School Board, but we use your office because the legislature doesn't want to give us the funds directly because then they have to set up another agency and do that. So for functionality, you are the ones that are cutting the check. And that is why there are those certifications that are going to your office as well. And it actually expanded it just from startup to any, also MSP funds and anything that does come through, directly to your office. But so you have those certifications. The thing here is why ask for documentation if you don't have reason to question those certifications? If you have reason to question those certifications, then by all means ask for documentation like you do in other instances. But here you're saying that you're assuming like there's going to be problems. You're assuming that you have to get all of that documentation. If you're just going to ask for the documentation, there's no point of the certification in the first place.
I just wanted to provide some clarity. This might help in the statute that Jennifer referenced. It says that the State Charter School Board shall use money appropriated for charter school startup costs to provide grants. So the money is already set aside and appropriated. We're just kind of the conduit that the money flows through. Right? Did you have more further? Okay.
We're the conduit for all the funds.
Right.
It doesn't matter whether it's charter or, and we are responsible to go back to the Hill and say, this is where the money went, this is what happened to it. The State Charter Board is not responsible for that. So I'm kind of really tipping here.
But that's why you have the certifications. That's why you have all above that, all of the certifications that have to go to you. So you're already getting that. This is just saying that it's kind of like you ask all these assurances of LEAs every year, and it's kind of saying, well, yes, you're giving us the assurances, but we're going to assume that there's always going to be problems. So we want documentation when you're giving us the assurances. We also want every single time for every single LEA all of the documentation. No, it's appropriate to ask for that documentation when you have concerns or when there's reason, and so you're not asking of all of them.
But I would ask the same question, what are we doing with LEAs that the other district schools? What's different? How often do we spot check them, and should this be not all, but do a spot check? The other thing is, are you asking these questions? I guess that's what I would ask. And if this also includes MSP funding, then we should, I know that this doesn't.
This is just startup funds, right?
It actually does. On line 80, it says including minimum school program funds.
So it might say startup here, but anyway, so.
And can I explain why? I could provide some context.
So I'm really struggling because I get the kind of freedom, but the buck still stops here. I've got to sit before the legislature and say, this is what happened to the money. But we do, Jen. You might say it's you, but we are still responsible for every dime that flows through this building. We're responsible for it.
I have a clarification. So this is where we are asking within 45 days, we get from the authorizer certification saying that everything is in order before we distribute startup funds. So it wouldn't be from every single charter school. It would just be from the ones that are currently starting up, right? The new ones? Okay.
Well, if I can.
Yes.
So I think, Member Belknap, my point isn't that that you don't have that oversight. My point isn't that you don't have to be the one reporting. My point is that you're already asking for the certification. This does not, if you get.
Sorry to interrupt. Where does that certification
It was new in the one that you just approved last month.
Line 91.
Tell me about it. Tell me, where did it come from?
It was something.
Who created it? Who certified it, quote unquote? Oh, sorry, because I'm kind of overstepping, Michelle.
Yeah, you are.
I'm trying to get clarity here because I'm a little bit lost.
The certification was something that over the months that we worked out of how to do this, how to provide that oversight as was intended by, HB 313, where you're creating the box in which the authorizers
You created
operate.
the box.
313 and our
Three-
rule did.
Our rule
in the
did.
rule.
Okay.
So all of us were working together. Your staff, we were working with
So
them.
the box
and
is created
So
and
the
they check it.
certification is new. It was something that, just hearing, and concerns and in thinking about this, many of the concerns that Member Lear was talking about, that you're not sure, well, is this school going to be okay? And so you get these certifications. If you have reason to doubt it, then you always have that right to ask for the documentation. Taking out lines 116 through 119 doesn't eliminate that right. It doesn't take out that you're getting certifications that this money is spent well, or your ability to be able to look in deeper when you have questions or concerns. What it does is, if you don't have concerns, let's take it away from us. Let's say the awesome school district of Utah, it becomes an authorizer and they authorize a school. And you have absolutely no concerns because they're the awesome school district of Utah, and so they're doing a really great job. Why make them provide all of this documentation and your staff to receive it when there's no concerns? Why not just go after the horrible authorizer of Utah that is not doing a good job of authorizing, that we just ask them to provide that documentation.
I just want to make one comment, though,
Okay,
Michelle.
and then
is that-
Angie has
is
a
that
clarification.
I think that we should be looking at every school that starts up. I don't care where they come from, because we have to not be closing schools in their first few years. And so I think we should be looking at all of them.
Angie?
Us or the authorizer?
Both.
I think Angie has some clarification to that.
Well, I just wanted to clarify. I think Jennifer has stated it. In the rule currently, there's a certification that's required, and that is what we passed, the board passed in November in 552, and that's on lines 80 through 82. And part of the certification includes all of that information. And it's for the startup funds as well as MSP, because the staff felt like this would be a good time to make sure that the school has everything in order before the superintendent distributes the money. And I think you are correct, Board Member Belknap, that although the money is the statutory duty of the State Charter School Board to administer startup funds, the reality is that the money at the end of the day flows from this office. And I know that Scott Jones and Natalie Grange feel like if we were ever audited and there were ever a problem with how that distribution occurred, any documentation that an auditor would need, they would likely not just audit the State Charter School Board, but it would be about the State Board of Education's fiscal practices and how we distributed the money. So I think there's a shared responsibility there. I don't think it's as simple to say it's the State Charter Schools Board's duty to administer, and so there's no liability on the board. As long as the money is under the budget of the State Board of Education, it comes from the State Board's fiscal office, there is a role there, a shared role. But the question, I think that's the key question that you need to determine is certification sufficient, which the rule currently requires the certification to the superintendent prior to the June 30th of the date in which the school is going to start providing services to students? Or would you also like to require the documentation to be provided at the same time? And I think that's where Jennifer and Royce have stated that they think the good policy call would be to just allow the superintendent to request that documentation when they felt like it was necessary, versus requiring everybody to provide the documentation. So I think that's the policy call at the end of the day is, do you want to just let the documentation be asked for at a later date or upon request type thing, as needed? Yeah.
Royce?
So I think there are two flavors of burdens here that you have to consider. One is the additional burden that an authorizer would have to provide in providing all of that documentation. The other one, though, is you as the state board have to figure out what are we going to do with all of this additional data. I mean, they're providing a variety of assurances saying we did X, Y, and Z. There are, I don't know how many reports behind each assurance. But you have to decide, do you want to add that additional burden to your staff on that? Or do we want to simply say, we will dig into those weeds when something pops up? I've got coming to to UAPCS member meeting on Monday, Scott Jones is going to come and talk about some of the efforts that the state board is doing when it comes to special ed auditing right now. You could, as a state, require every LEA to submit even more documentation about special ed than you do today. But for a variety of, I think, good reasons, you say, we're going to trust that you're doing things right. You assure to us that you are. And when we get wind that there is a problem, then we want to verify that things are going on. There is a real burden on you, on your staff, that comes with the additional documentation.
Okay, thank you, Royce. Yeah. Go ahead, Jennifer.
I also want to add the certification has not been done before. And so perhaps you want to see what you're getting with the certification, because this is something that, as an authorizer, we've never passed on this information. We've never, you now have to find out things that you want every authorizer to look at for these new schools. And so you haven't tried the certification yet. I think that part of this is thinking of what has been done maybe in the past where you didn't get anything and say, now we want all of this documentation. You have never gotten that certification in the past. We're now giving you that certification, and we have to do that before the schools can receive money and funds. I would suggest that maybe if you find that the certification isn't enough and that in the future you want all authorizers to have to provide also documentation, maybe think about that as a future amendment. But right now, maybe take just try and see, are the certifications sufficient, because you have not received those in the past.
What are you doing?
Board Member Brittany Cummins.
What's going on here? Okay, so I have, my first question is to make sure that I understand rules as written. So Angie, I might need some help with this question, because I'm still stuck on the, if 116 to 119 only applies to subsection 2. Because in there's a 2 in parentheses on 116 to 119. Does that refer back up
the whole
to the 2 up on line 75?
So yeah, it would be the financial identifying documents, the completed background checks, and then the executed or signed charter agreement.
So I'm looking at 2 on line 75. What 2 does it refer back to?
Yeah, it would be that 2. It's 75 through 79.
Okay.
So it's all of the
3,
information.
which is line 80, which talks about the minimum school program, would be outside of what that is referring to. Is that correct?
Well, yes, but 3 also refers to subsection 2. So do you see where it says?
Correct.
So in some ways, I think what you could do is actually have, there's 2 ways of doing this. One thing that Michelle and I were just talking about is you could have lines 116 through 119 just say, upon request, somewhere that the state charter school board shall provide the documentation to the superintendent. Or you could, in subsection 3, just say a charter school may receive state funds if the charter.
Angie, sorry to interrupt. I know you're trying to get to the concept, but I'm trying to get to how a rule works.
Oh, okay.
Like, just very specifically, because then that goes to the concept and how it's written.
Okay.
Because if I don't understand how a rule works. So 116 to 119 only refers to subsection 2. It doesn't refer to subsection 3, which is the MSP funding.
I see your point.
Is that correct? Am I correct in that assumption that this only then, because of how 16 to 19 is written, it would only apply to the startup funding?
Probably.
Okay.
But, so, can I just clarify something,
Okay.
though? So what you're saying is that the certification would be needed for the startup funds and the MSP, but you're saying the way we've drafted it, then it looks like the documentation would only be provided for the startup funds, not this.
Startup funding, not
Correct.
for all funding.
Correct.
Am I
That makes
correct in
sense.
that
Then
understanding?
that might
Is
not be
correct?
what the policy is that you want. Correct.
Okay. So then that gets to my overall question is 116 to 119 necessary? If we have the right already, do we have the right under the rule right now to request documentation? So if they receive a certification and Angie over there, or sorry, oh my gosh, Mandy Barrett.
Jamie.
Miss Barrett, Jamie. Sorry, I was like, how did that just like... She all of a sudden is like, well, wait a second, I'd like a little bit more documentation before we send this out. Can she request of Jennifer Lambert, can I see the documentation on this particular item? She has that ability and
I
that
would
right
say yes,
currently
that we
without
have,
it.
yes.
So I would like to move that we strike out lines 116 to 119.
Okay, so the motion before us is to strike out lines 116 through 119. Any discussion of that motion, Royce?
I will just note that given the change you made before, and it looks like the change that you're about to make here, the same change would then apply later on, and
With 165 and 168.
If you're going to do that here, you should probably do it in both places, because the
And
issues are
198.
exactly the same.
It's in two other places.
Although.
So, yeah, I just want to do that one at a time so that I
Okay.
can make sure that I'm understanding the rules as we go forward.
Okay, so we have a motion for us. Board Member Belknap, did you have any comment to this motion?
I do.
Okay.
Because I think it's reflective of it. So my question is, who verifies the assurances or the certification that comes? So that we know that these schools, who verifies that? We get a certification and someone says, I've done this, 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 and this, or I'm here. Who verifies that?
So that would normally be that, right now, that those assurances come through the ops department. And the question is whether we now will have a staff person that will look at these specifically and follow up on them, because it kind of depends on the program. So sometimes we receive the assurances, and unless there's a risk that's identified there, we trust them. We trust that when they certify that they did this, yes, they did
But
it.
in the rule, since it refers back to line 75 to 76, part 2, it says, and the superintendent. So would it
The
be?
superintendent's out.
Would be
That line,
out.
We already took that
Oh,
out.
we struck that out.
See,
Just
so
Yes.
Okay, so we already talked about the fact that Miss Barrett
That's true.
can talk to, like, so we talked about awesome authorizer and bad authorizer, but what about neutral authorizer who's brand new, hasn't done anything? They can begin that process of, oh, we've got a new authorizer, we're going to verify these assurances. I'm going to call authorizer A, I'm going to ask for documentation. We have that right currently to do so. Then we've worked with neutral authorizer 7 times, and every time everything has been 100% accurate. I'm not going to ask for documentation this time because every other time I've asked, it's been 100% accurate, right? And so now neutral authorizer is now awesome authorizer status, and they have the ability to verify every time.
Okay.
If we don't have the ability to verify, then please tell me and we can make sure it's in here, but that we already have that ability to verify any documentation that comes through with the certification process.
Okay, Board Member Belknap?
So when in the process is that done? Because I feel sometimes in the whole conundrum with the board, the state charter board, the verifying, the certification, that it kind of all gets conjumbled, and that someone gets their charter before things are verified. Does that make sense?
Yeah.
If I understand the process correctly, these charters have already been approved. These are approved charters that are waiting for funding to come through. This is the certification of hit the button, the funding is to go out. And so they've been approved, and they're doing lots and lots of work. Now,
And what if their certification, then my question would be, what if their certification doesn't prove to be true? Now we've got kids on the hook, we've got teachers on the hook, we've got finance on the hook, buildings on the hook, and so
no money has gone out yet.
I know, but what I'm saying, no money has gone out, but there's a lot of other things that have happened in the.
That happens
all the time?
All the time.
Okay.
Anytime a charter gets an approved charter, you've got 500 kids saying, ooh, I might want to sign up for that, right? And so those kids, they make a choice to be on that hook, knowing that funding has not been approved yet.
No,
That's the way.
They don't know that hasn't happened yet. I would say kids don't know that yet. Families don't.
When we signed up for George Washington Academy, it was being built, and there were times when we were told, it may not be finished. We don't, in St. George. So we were pretty well aware. I mean, we were lucky, and it did get finished, but
some don't.
We were told.
Okay.
Yes.
I just wanted to raise one more issue. I mean, right now, Jennifer and Royce are stating that they agree that the board has the authority to ask for this documentation and that they would willingly provide it. Probably be a lot easier for us to track down Jennifer for that information than maybe another authorizer, because they're right here in this building. But there is the possibility that at some point an authorizer down the road, or even the state charter school board, if they have leadership changes and say they don't work as well with the board as they do right now, we have a great relationship with them right now, I would argue, as well as Jamie, that we absolutely have the authority to get that documentation. The one thing that there always is a risk is that if we don't put it in here that the authorizer has to provide that documentation, somebody could make this argument down the road. Well, HB 313, you can't do that now because this bill was drafted and it didn't explicitly say that you could ask for that documentation. Now, we would fight that, and I think that because we have the right to distribute the funds at the end of the day, we would have that ability to hold the money back until they provided us the documentation. But I do just want to raise that there are possibilities that somebody somewhere down the road could fight us on it. And if we had it in there that just says either upon request or, but I get your point, Board Member Cummins, that why put it in there if we already feel like we have that right? So I just wanted to throw out that that is a possibility somewhere down the road if an authorizer doesn't want to cooperate with us or provide us documentation upon request. So.
With respect to my good friend Angie, I think that the board has significant authority here. Insofar as rules that you've already adopted point out that you, the board, have the ability to ultimately say, no, you authorizer are being recalcitrant along a variety of dimensions, and so you don't have authority to authorize. If somebody wants to play Russian roulette like that, they're welcome to, but you guys really do have a very big trigger. And 313 is frankly designed to say you have that trigger. It's designed to say that you, the board, oversee what, whether or not any given entity is able to authorize. The legislature can say, yes, this entity is conceivably allowed to, but you, the state board, still have to put a stamp of approval, and you are more than capable and empowered to withdraw that stamp of approval.
Jennifer?
So that was also my, the thing that I kept thinking of, because Member Belknap, you were asking about, well, what is the recourse? The recourse is to take action against the authorizer. And that's where 313, it kind of puts us in a different mindset where you have the authorizer that's doing all the work, like what Member Cummings was talking about before, that the authorizer is getting into the weeds. They're understanding these things. And if you can't trust them, then you need to take action against the authorizer. And that's where it takes it to that level so that you have that supervision and control. I also want to point out the things that we're talking about here, again, you've never had this in the past. You've never been getting these certifications. Once a school has been opened, funds just flow. Unless the authorizer closes the school before they open, you just automatically have flowed the funds. In working with your staff, we have found that they have concerns about flowing funds to schools who may not be ready. And so this certification was added. So this certification itself is already giving you hopefully a little more room to sleep at night, a little more assurance about these schools that are opening. And so I would just ask, if it ever comes to where we just don't work well together, then you can always change your rule and add that if you find that they're not responding well to your request. But right now, because you are the Board of Education, you have the ability to check up on assurances like you do in any case. And so it seems odd that you would put that here where you don't put it in all your other rules when you're talking about things that LEAs have to do or entities have to do. And so I would just argue that it's unnecessary and it is unduly burdensome.
Board Member Belknap.
I appreciate both those comments, actually. I also know that it looks good on paper, and in practicality, it's not going to work that way. On paper, it works good.
Board Member Brittany Cummins.
Okay, so I'm a little bit lost in the rule. So line 80 is the beginning of subsection 3. Can somebody help me find the beginning of subsection 4? Oh, sorry, I found it. An authorizer shall create a process for verifying the requirements in subsection 3. And then C says, provide the documentation described in subsection 4B, maintain documentation of 4A to the superintendent upon request. So it's there.
Yeah, it's there.
Okay.
Yeah.
All right, sorry, I couldn't find where it was referring to. I was like, I'm lost here for a second.
So basically, 116 through 119 they're already covered in the rule anyway.
They're redundant.
Yep.
Okay, so the motion before us is to strike out 116 through 119.
Yeah.
Any further discussion, Lisa? Did you have any further discussion to that motion?
Not to the motion, but just to the overall. I think a good leader allows their team to lead and to do their job. And I think this Utah State Charter School Board and the authorizers know how to do their job. And if we have any questions, like this rule states, we can then ask questions and interject. I think to be the end buck stop here oversteps our bounds and oversteps their job. So then why have their job, right? So I fully support repealing all the sections that have been in place because it's redundant.
So are you making a...
So I am...
There's already a motion.
There's already a motion.
Amending her motion.
I don't think so.
Are we going to do it by section, or I can do it all at once?
We're just...
If you want to make no changes to the rule,
You could just
Okay,
table
so
them.
then
Yeah. Right now, the motion before us is to completely strike out lines 116 through 119.
Right, but I would just like to say, let's not make any changes, and we don't...
The last one was a good change.
Last one was a good change? Okay, was a good change? Okay.
Yeah.
So then I'll just...
I could shorten this for you if you want.
Yes.
Yes,
Okay.
we just go with the motion.
If you'd like, if it sounds like you only like the changes to section 7, which is the last section of the rule, you could make a motion that the amended, what will be draft 2, will be only the amendments to R277552 section 7. But I think you also want to make an amendment to that to add a subsection 8 that requires the current authorizer and the board to provide the information. And I have some language that I can show in just a moment. But is that the motion you like to make, is
Yes.
just to accept the amendments
that would be an
in
amended
section
motion
7
to-
as amended? And then we'll just do that.
Because we already have a motion on the table, so we would have to amend.
Unless that motion is withdrawn.
That's fine.
Okay, so,
Without
Yeah, well, we're not big enough to
that's fine.
do it, so we'll withdraw the original motion. Board Member Brittany Cummins?
There's a word on line 229. Is that?
That's in section 7. So all of lines 210 through 243
section
are
7, not
section.
subsection 7.
Yes,
Thank you.
yes.
Sorry, you're killing me today, Angie.
We're all
Thank
learning,
you.
drafting
Wait,
together.
oh,
right?
I get it.
Yes.
I was
Section 7 and subsection 7 within section 7.
Okay.
Yeah, I'm getting back on. Ben took off. I'm gonna drive now.
So basically, the motion.
Okay, let me help you with the motion.
Yes, help me with the motion.
So
Hold on
I just
one
want
sec.
to make one
Yes.
clarification first. I know we went through that word by word in that first section. So understanding that, are those same certifications and assurances carried over into those other areas of replication and satellites, et cetera? So.
Right now, Jamie, correct me if I'm wrong, okay? I don't see any certification requirements in the expansion and satellite, but it does describe a process that the authorizers have to go through before they approve an expansion, a satellite, or a replication.
It starts in line 162 and it references 5.
Request for an expansion.
Is that it?
Well, it's the charter school who wants the expansion has to provide that information to the authorizer. But I don't believe any of them have anything about providing information or certifying in writing to the state board, but I could be wrong. Jennifer, is there something you want to bring up to our attention?
Jennifer.
So according to, again, the way that it now is being done with HB 313 is that you certify an authorizer's process. So an authorizer has to bring to you their process. You look at their process and you say, this is good. Then I believe it's within 45 days or 60 days, there's a certain timeline that if you believe that the authorizer did not follow their process, that they did not follow according to board rule, then you can question it. So it's already in statute that you have it there, and again, so it's unnecessary to have it here.
But the expansion one.
We could just say the superintendent may, just do the same language we have in an authorizer shall provide the documentation described to the superintendent upon request. Jamie, was there anything
It refers back to line 4, see 231, 4, the current authorizer.
Yeah, we're still in a different section.
Oh.
Though. We're in section 5 right now.
So.
Section 3 refers to certification.
Say that again? I think.
75 and 76.
Yeah, but that's only for section 3. So if you wanted the same language that an authorizer shall provide the documentation described in 4B, I mean, I think that's essentially what is being done in lines 165 through 168. If you wanted to keep it, you could just say, upon request, the authorizer shall provide documentation, you know.
So Royce?
If I may, in many ways, this question goes really to the heart of what 313 was about. And so what 313 said was we, or you, the state board, will verify that a proposed authorizer has a process that meets the standards that you have set. Once you have comfort that this authorizer has a process, you're not going to look over the shoulder of that authorizer in the process of evaluating a new charter school, an expansion, or a satellite. There may be some unique circumstances, as Jennifer indicated, where someone, maybe there's a hotline call in the first 45 or 60 days, whatever that is, where you say, we need to verify something. But as a rule, what HB 313 said, we or you, the state board, are not weighing in on a specific application. Rather, you're verifying whether or not the process that any given authorizer has will meet the minimum standards that you, the state board, have set. And so requiring assurances about a specifically authorized school, whether that's an expansion or a satellite, would seem to me to be very counter to what we were trying to accomplish last year.
Can I make a comment? So because we're talking about expansions, satellites, and replications, I did want to bring something to your attention because I think there's a possibility that there might be a statute request change or legislative change. And I just want you to consider this now before the session comes, and then understand that currently in statute, it could be implied that any increase in charter school enrollment needs to be approved by the board. However, the language in statute also states that you describe that process in rule. So what we have in rule works, but I think that if somebody wanted to make the argument that the state board still explicitly needs to approve every increase in a charter school's enrollment, you could make that case. So there's a section of code 53G6504, approval of increase in charter school enrollment capacity, and you can see expansion is in there, that was not included in HB 313. And I think thinking back on that, I think it's because most of the focus was on the application process and stopping the individual applications from coming to the board. But a related issue has always been, and you know, the board has received requests for expansion or replication or satellite schools, which are generally an increase in enrollment of a charter school. So this section of code says the State Board of Education may approve an increase in charter school enrollment capacity, subject to the legislature appropriating funds and authorizing an increase in charter school enrollment capacity, et cetera. Some of this language is was very needed and is applicable to when charter schools were funded on an October 1 count versus currently they're funded the same way that school districts are, which is based on prior year enrollments with an October 1 bump. I don't want to get too much into the details, but there was a reason why there was a time where local school replacement had a certain monetary cap, and you really had to be careful about what charter school enrollment was allowed or not, because it could really have a financial burden. Now, because charter schools are funded much in the same way that districts are, and it has a prior year, it's based on the prior year's enrollment, I think there's less of a likelihood that you're going to have those fiscal problems of the past. Although, Jamie, you can correct me if I'm wrong. There's other provisions now about local replacement being proportionate. If a charter school increases their enrollment significantly, that then, and there's not enough money in the local replacement, that we prorate the amount down for those schools who over-enrolled. Am I saying that correctly? Okay. Yeah, because I knew I wasn't saying.
You can come.
But before, as Jamie's coming up, you can see in subsection 5, also you have board rulemaking authority to determine how those increases are approved. And so right now, again, the board will not be, in accordance with this rule, the board will not be individually approving each of those enrollment increases, but instead the data, the certification, will be provided to the staff or the board by October 1, right? Or is it not provided? It's just getting ready. They have to approve all the increases by October 1. Is that what it states? Okay.
Sorry. Yes, go ahead and state your name.
Jamie Barrett, Minimum School Program Administrator. Why that October 1 deadline is so important is because for new satellites, established charter schools that are expanding into a new grade band, or if they're brand new charter schools, they are funded on the October 1 head count, their first operational year, not prior year ADM plus growth. So there is a difference in funding that first year of operation, which is why we have to have those counts by October 1st in order for the budget.
Can I say something else
Yes.
before Jamie leaves? And although it doesn't state it in this rule, isn't there another place where all LEAs have to provide their projected numbers, any growth, increases in enrollment to you by October 1 for projections?
It's only charters.
Yeah, it's
Oh,
only
it's only charters,
only
but is there
charters that do
another
that.
rule that states that that the authorizer has to provide those numbers?
It's 484.
Yeah.
But now is 484 is going to go
No,
away,
We
right?
talked about it.
Okay.
It's in one of the new ones.
Is it, okay, so we're good, right?
Right. Right.
Okay.
CDC doesn't, the growth in district.
I mostly wanted you to be aware that I believe there may be a request for a change to statute about this. Maybe it's not necessary because the rule is in compliance with it. If you had any thoughts, it'd just be better to talk about it now before I think the session comes, or, does that make sense, Jamie? Okay.
Okay. Board Member Brittany Cummins.
Then I'd like to move that we approve R277552, draft 1, with only the changes that were made to section 7.
Did you want to, I didn't know if you also wanted to add that.
And with the additional subsection 8, with the superintendent and current authorizer shall provide the information described in subsection 7 to a new charter authorizer within 30 days of request described in subsection 7.
Does that seem reasonable?
Okay. Okay, so the motion before us is to adopt R277-552, draft 1, with only the changes in subsection 7, in section 7, and add the addition of subsection 8. Okay, on first reading and move to the board for second and final reading. Did I say that motion correctly?
Yes.
Okay, any discussion to the motion? Seeing none, we'll vote. All in favor? Aye. Any opposed?
And Terrell is online, we
Oh.
just can't hear her.
Okay.
It's just like yesterday.
Just like yesterday, she was probably an aye. Yeah, we were having hard times yesterday. Okay, the motion passed unanimously, and that's, we're done.
I don't think so, because you can't hear her.
Yeah, we can't hear her, so we can't count her vote. That's the end of our agenda, so we're done. Law and licensing is over. We're done. Meeting adjourned.
Way to go, Michelle.
I actually think moving the big items to the end is way better.
Yes. We'll make sure we do that.
Or sometimes we don't know which ones will be
I
big.
know, sometimes we don't. That's true.
We may think.
Hey, awesome. That was easy peasy-ish.
Easy peasy.
Well, when we have smaller and a smaller family, and half of the
That's
things
true.
we talked about
We did,
last
yeah.
year, so that really helped, because if you think
Because a
about
lot of it was just-
707 could have been more complex if we had, and the pedagogical assessment could have been more complex.
Because we
but
already
had
had that discussion. Yeah.
I have cookies here. Brian, want a cookie? They don't. Deb, I have a cookie. I have a cookie.
It would be interesting to see. I'll see where to put it.
Thank you.
I don't know where Michelle is. I mean, Lisa. She
I'm
probably
like,
won't want
I'm
it.
here.
I know, no, it's for you too. I'm all about committees. Just committee group.
I'll take a good. So did you guys notice that Jamie and I have the same shirt on?
No, I did not.
I've been eating this because I can't take it on the plane. I don't want to deal with it.
Oh, I almost wore a flower top.